very good morning to all of you. I'm happy to have this opportunity to meet you all via this media. And I'm Professor Beulah Shekhar from the Manonmaniam Sundaranar University in TIRUNELVELI. I head the Department of Criminology and Criminal Justice. I'm here to talk to you today on a topic very pertinent to all of us, and it is towards a victim justice system, the need for a balancing act. For a few minutes to dwell on the topic, I'm talking about the balancing act between the rights of an offender and the rights of a victim. So let's proceed and see what I have to share with all of you today. Since this webinar is hosted by the FX College of Engineering and by the Computer Science Department, though this term victim pertains to the victims all over the justice, all over the country and all types of crimes, I'd like to talk a little about the history of the cybercrime. So we know victims. When I talk about victims, there are victims of all types of crimes, cyber crimes, conventional crimes, and even abuse of power. So now let's look at the history of cybercrime. The first recorded cybercrime took place in 1820. I don't know how many of you are aware of that, but we might wonder whether there were computers back then. How could it be a cybercrime? But there was a textile manufacturer, a Frenchman called Joseph-Marie Jacquard, and he owned a textile mill, and he produced a programmable loom. This programmable loom that he produced allowed the repetition of a series of steps in the weaving of special fabrics. So this is a sort of digital computer that was used by IBM to develop the modern day computer. So once this came into being, the employees were very worried about losing their jobs, and they thought that their livelihoods would be threatened. So they committed acts of sabotage to discourage Jacquard from using this technology. So as history records, Joseph-Marie Jacquard was the first recorded victim of cybercrime. So this increase in cybercrime and increase in the number of victims of various other crimes is peculiar not only to India, but all over the world. We see that there is a large increase in the number of victimization and the number of victims. Hence, we need to talk about this pertinent topic of victims and how the system moves towards a victim justice system. So first, when you look at the magnitude of the criminal victimization, there are so many types of crime, and cybercrime is also rampant. And as we speak, the numbers of crimes are increasing, especially when it comes to cyber crimes. The cyber criminals get away with millions of pounds, dollars, rupees, yen every year. And this happens, and when this happens, when you say that there is no punishment for the offender, when there is impunity, that means the person who suffers is the victim, because he has not got justice. There's no access to justice for the victim. So the statistics tells us that for every one criminal that gets caught, 10,000 or more go free. So we see how many victims are left without access to justice. So we have some statistics in UK. They say that less than 10% of the investigated of the crimes were investigated, and only 1% were prosecuted. So this is not only peculiar to UK, but it reflects a global trend in which the cybercrime capabilities in many law enforcement agencies, they struggle to keep up with the ever-evolving cyber criminal activity. So that's the reason why there is this impunity when we talk about cyber crime and cyber victimization. So when you look at cybercrime vis-a-vis the conventional crime, so cybercrime seems easy to commit, Whereas the conventional crime, it was a little difficult to commit. But here, with a click of a button, mouse, and a click of a button, you can defraud many people. So cybercrime seems easy to commit, but the reality is it is more difficult to detect and most difficult to punish. So in case of conventional crimes, it might be difficult to commit, but it's easy to detect because there are a lot of physical evidences. So that's why you see that there is a lot more cyber victimization than we have in the other types of victimization. So this is a little bit of background for people who are not from the criminology or the law or the social sciences. So this, when you look at the system, when you look at the justice system in most countries, it consists of 4 wings. That is the legislative wing, or the laws. The laws are made by the citizens. So the legislative wing and the enforcement wing. Enforcement wings are the policemen, the ones who enforce the laws that are made by the citizens. And third comes the judicial wing. When the law is enforced, we need to bring the person to the judicial system, to the courts, to assess whether they are convicted or acquitted of the crimes they're accused of. And finally comes the correctional wing, which is the last wing, which talks about the correctional, the cells, so to say, when the punishment is decided by the judicial wing, then how the person is punished and what kind of a system there is to correct that person. So these are the 4 wings of the criminal justice system. This is just to give you a background on what we're going to talk about. So in this system, you see that there are laws, there are policemen, there are judges and the courts, and the correctional system, that is the prisons and everything. In this system, the whole criminal justice system to be set in motion, for everything to take effect and start acting, the first thing that must happen is the victim's complaint. Once the victim who has suffered a crime, he has to come and report the crime to the criminal justice system. That's when the whole system is set in motion. So I would call him the very important person of the criminal justice system, because it is he who holds the key. It is he who, when he steps into the police station to register his first information report or his FIR, or it is he or she when they pick up the phone to call 100, when they register the complaint, that is when the whole system is set in motion. So that is why he is the VIP of the system. So in the next 45 minutes or so, we're going to talk about not the type of cyber criminals. You might have heard a lot of webinars and other lectures about the type of cyber criminals, about the different types of cyber crimes that are happening. But we are not going to talk about all this. We're going to talk about the plight of the VIP of the criminal justice system. That is the victim. We're going to talk about the plight of the victim. So the likes of Jacquard, the first cybercrime victim, and others that followed. This is what we're going to look at in this lecture. So you see that there is a kind of imbalance between the two, the victim's rights and the offender rights. I'm trying to show you in this lecture about how this happens and what can be done to set this right. So when you're dealing with criminals and victims in today's courts and in the justice system, we face a lot of challenges. One mainly is there are 2 types of systems, the acquisitorial system and the inquisitorial system. So we see vis-a-vis how these are pitted against each other. Second comes the victim rights vis-a-vis the offender rights. This is a kind of outline of what we'll be looking at today. Then the third comes the victim rights vis-a-vis enforceable victim rights. The fourth would be victim assistance vis-a-vis crime prevention. And the fifth and the last one would be the criminal justice system vis-a-vis a victim justice system. So we're trying to set right this imbalance. We're trying to see what we can do to bring about a balance between the victim rights and the offender rights. So the acquisitorial system vis-a-vis the inquisitorial system. So like I told you, most countries in the world today adopt one or two of these legal traditions. One is called the adversarial, and the other one is called the inquisitorial system. The adversarial system is also called the acquisitorial system. So the first system, the acquisitorial system, is popular in common law countries like UK, England, Australia. We follow this system, India also. So here the prosecution and the defense, they compete against each other. So there is a prosecution and there is a defense. So two lawyers, one the public prosecutor and one the defense lawyer, they are pitted against each other. And the judge merely serves as a referee to ensure that fairness is given to the accused and the rules and procedures are also followed. So in this system, we have an extensive pre-trial investigation and interrogations and all these things so that the innocent person isn't brought to trial. So the main aim of this system is to protect the innocent. So it assumes that the best way to get the truth of the matter is through a competitive process. That is the defense lawyer and the public prosecutor. So the judges in this system, they serve as a negotiator between the claims of the prosecution and the defense. So they kind of try to see which is right and which is wrong. So their role is kind of limited. Now let's go to the inquisitorial system. This is followed in many European countries, and this process can be described as an official inquiry to ascertain the truth. So here the main thing is finding the truth. So the inquisitorial process can be described as an official inquiry into the system to ascertain the truth. The inquisitorial process, it grants more power to the judges who oversee the process. So the judges can kind of regulate, not merely negotiate, but kind of regulate the process in this system. So we're going to see what is the difference between these two systems. So when you look at the countrywide distribution of crime, so you see that the largest chunk is US, followed by India, UK, and other countries. And you look at the top 10 countries again, you see that these are the countries that have the large numbers of crime that happen in their countries. So when you look at it, you see that these are all the countries with a high crime rate. They are the common law, and they are the countries that follow the acquisitorial or the adversarial system, like the common law countries. So these are countries which have larger crime rates than the countries which follow the inquisitorial system. So now, when we try to figure out why this happens, we look at what an Australian Justice Russell Fox, he once said. He said, justice means fairness. Fairness means truth. Truth means reality. And the search for the truth gives a legal system its moral dimension. Otherwise, what happens would be the likely winner will be the one with the most money and the cleverest lawyers. So this is the reason why we see that there is more crime in these kind of countries which follow the adversarial system, where the objective is not to get to the truth of the matter, but to protect the innocent. So now let's look at our acquisitorial system or the adversarial system and see what happens here. Our system does not try to find the truth. It does not tick any of those Justice Fox's boxes. So now we have a big question. Do the number of acquittals have a bearing on the increased crime rates in these countries? Can we maybe say that all the acquittals and all the minimum number of convictions in these countries that have the common law system, the common law countries that follow the adversarial system, are they in a way contributing to the increase in crime rates in these countries? This is a question. So most of these slides might make you think. We have a lot of questions for you, and we need to think about it and see why these things are happening and what can be done to prevent it. So when we see the criminal justice system, not only in India and UK, in all these common law countries, with these high crime rates all over the world, they have their basis on a very ancient, archaic legal maxim, an English legal system. It's called the Blackstone's Formulation. You must be wondering what this Blackstone's Formulation is. So it was Blackstone who first said it is better that 10 guilty persons escape than one innocent person suffer. So this is the emphasis of the adversarial system. They do not want to punish an innocent person. So the focus is on protecting the innocent. So it is better that 10 guilty persons escape than one innocent person suffer. So what are we doing here when we say this? When we follow this Blackstone's formula, what are we saying? We're taking great precaution, or we are being overcautious, which leads to offenders going scot-free, impunity, crimes going unpunished, no deterrence. And when there is no punishment, there is no deterrence. And last but not the least, no justice for victims. So we have a great sociologist who has also contributed a lot to criminology, who has said, Jeremy Bentham, he has said, very rightly so. I always emphasize on this saying of his. We must be on guard against those sentimental exaggerations which tend to give crime impunity under the pretext of ensuring safety of innocence. So when you're trying to protect, to be overcautious, you're losing out on many, many victims who do not get justice. So a Roman doctrine, this Blackstone's formula is also has a background on a Roman doctrine which again states that it is better to let the crime of a guilty person go unpunished than to condemn the innocent. So this is the one that is reiterated in the famous English jurist William Blackstone's words as well. It is better that 10 guilty persons escape than one innocent suffer. Now, when you look at this, I'm trying to rephrase it. So when you try to rephrase this, what does it read as? Think about it. 100 accused can go free, but one innocent man should not be punished. When I say that, what am I saying? I'm saying 100 victims can be denied justice, but one alleged offender should not be denied justice. Is this fair? So that is why we have our very own Justice V.R. Krishna Iyer, who has said victims have become the Cinderella in the criminal justice process in India. Our focus is on the offender, how to protect his rights. But in the bargain, we lose out on the rights of the victim. So victims, like we all know the story of Cinderella, victims have become the Cinderella in the criminal justice system of India. So now we know why we have this kind of an injustice. So it's not only Justice Krishna Iyer who said it, but we also have another justice in the US who said that justice, though due to the accused, is due to the accuser also. And the accuser here is the victim. So justice, though due to the accused, is due to the accuser also. The concept of fairness must not be strained till it is narrowed to a filament. We are to keep the balance true. That's what the focus is on. We need to keep the balance when we are talking about justice to victims. So let's move on to the next part of our presentation, that is the victim rights vis-a-vis the offender's rights. So we've seen what is the acquisitorial system and what is inquisitorial system, and now we're looking at victim rights vis-a-vis the offender rights. Now, when you look at the offender rights, we have the D.K. Basu's offender rights, and it's called the 11 Commandments, which all the law enforcement officers are very aware of. When they apprehend a criminal, when they apprehend an alleged offender, they have to follow the set of rules, the 11 commandments. If they do not do that, they are taken to task by the human rights organizations, and it is their bounden duty to follow these rights when they're handling offenders. Now let's have a look at these rights. So you see these rights and you see that there is a very affirmative statement in these rights. So you see that the police personnel carrying out the arrest should bear accurate and clear identification. So see the word should. I'm trying to highlight the word should. Similarly, the police officer carrying out the arrest should prepare a memo. The person being arrested in a police station shall be entitled to have a friend or relative present. The time, the place of arrest, and venue of custody of the arrestee must be notified to a friend. The person arrested must be made aware of his rights. An entry must be made in the diary at the place of detention. The arrestee should be also examined at the time of arrest for major and minor injuries. The arrestee should be subjected to medical examination. Copies of all documents should be sent to the magistrate. So these are the type of rights we have for the offender. The police control room should be provided at where information regarding the arrest and the place of custody of the arrestee shall be communicated. So these are affirmative rights which are guaranteed to the offender. I'm talking about these rights in detail so that you will see the difference between these rights and the victim rights. So now we have the same rights in the US as well. I was a Fulbright scholar and I did a study on the status of victim in the US and in India. I did a kind of a comparative thing. So I'm referring to the US here. There also you have the Miranda rights in the US for the offender. And here again it says the offender has a right to remain silent, and anything the offender says can be used against you in a court of law. So you have the right to an attorney. If you cannot afford an attorney, the law one will be appointed for you. So these are again the rights of the offender. So now we've seen the rights of the offenders. We see how clear they are and how affirmative they are and how they really assure justice to the offenders. So now let's look at the rights of the victim. These rights we do not have in most countries, not in India as yet. So we have it in some developed countries, but these are the rights that are taken from the Crime Victims Act in the US. So a few developed countries have victim rights, and this is one of them, the US. So look at the difference in the rights here. The right to be reasonably protected from the accused. The right to reasonable, accurate, and timely notice of any public court proceedings or any parole proceedings. The right not to be excluded from any public proceeding unless receiving clear and convincing evidence. The right to be reasonably heard at any. So there's nothing affirmative. That's the difference between these rights and the offender's rights. So it's just reasonable, the reasonable right. So this reasonable is a very fluid word. It can be interpreted, it is subject to interpretation. So what's reasonable for me may not be reasonable for another person. So that I see as a problem with these rights. Then the right to proceedings free from unreasonable delay. So there's nothing affirmative here. And the right to be treated with fairness and respect for victim's dignity and privacy. So it does not say the officers dealing with the victim should treat the victim with fairness, with respect for his dignity and his privacy. And finally comes the right saying the right to enforce these above rights. Let's see what the problem with this last right is also. So even though it looks like it's guaranteeing some rights, that's not so actually. So I'm just trying to show you the difference between the two rights, and I hope you can see the imbalance there. The rights of the victim and the rights of the offender. Now, the victim rights vis-a-vis enforceable victim rights. So what they've said here is the right to enforce the rights. That means if my rights as a victim have been denied, I've given some mechanism to enforce my rights. Okay, now let's look at these enforceable rights and see if these are also kind of guaranteeing some rights to the victim. So I did my studies in this area in various countries like Australia, Hungary, Indonesia, Japan, South Africa, etc., etc. So in most of these countries, you see that it's not very affirmative. The rights of the victim and his justice to victim is not really guaranteed. In Australia, there's no penalty for non-compliance. Though there is an administrative charter, if I do not comply and give the rights to the victim, there is no penalty. In Hungary, a certificate initiates the victim support services, and there are very few psychologists in the system. Most of them are lawyers. So again, that lacks a human face when you're dealing with victims. They do not need people who know the law. They need people who can empathize and understand them. So that's what I saw in Hungary. And in Indonesia as well, crime victims remain as faceless parties whose rights are not legally protected and hence need for a specifically designed victim rights. So this is what was happening in Indonesia. And in Japan again, though a law exists, the societal response and the stigma of victims of sex crime lead to non-reporting. It's very much like what happens in India. So even though we say Japan is way ahead of us, the basic stigma of the victims still remains, especially when it is dealing with sex crimes. Then next, let's move on to South Africa, where I did some work as well. So there are many rights protected under Section 31(1) of the Constitution of South Africa, that is cultural, religious, harmful practices. These increase the vulnerability of victims. Like you have cultural and religious practices like that are harmful. And this again does not ensure the rights to all victims. So there are female victims who suffer from female genital mutilation, and they say that is a cultural practice. So there again, there is a big question mark whether victims' rights are really respected and are really enforced. Similarly, other than these countries, I looked at England and Wales as well as a Commonwealth scholar. And there again, it shows that the victim has just included in its system and is still at its infancy, the rights of victims. So what we've seen that it's just been stuck on like a sticking plaster. This system, which is a criminal justice system, it's designed for a totally different purpose. So in this system, they've just stuck on some victim rights. So this is not what a victim needs, not some sticking plaster over a system designed for a totally different purpose. The victim needs a system that will help the victim. Similarly, in Canada, the rights included in the Bill of Rights did not include an enforcement mechanism, and therefore they cannot be considered as rights. So when there is a right, there should be an enforceable mechanism. Like we have the writs, the writ of mandamus, the writ, all the writs that we have. These enforce the rights. The fundamental rights are enforced through these writs. These are kind of affirmative action that will help the victim seek redressal when the rights are denied. So in USA, again, they have some enforceable victim rights, which require the victim to enforce their rights through writs. Again, let's see what is the issue with making the victim enforce his or her rights. So though they say that these victim rights in the US are the real rights, they're enforceable rights, they're affordable rights, they're constitutional rights, they're modern rights, they're participatory rights, the American style rights, statutory rights, explicit rights, appellate rights. So these rights in the Crime Victim Act in 2004, this is the best that I've seen thus far in the countries that I visited and I worked in. But in these also, there are loopholes. In spite of the fact of this Rights of Crime Victims Act in the USA, the 2004 legislation, in spite of it being glorified, we have found loopholes in this act as well. And you see that how this act also does not provide justice to victims. So here again, the victim's role is just that of a participant. So the victim participates in the process, which we do not have in our country. Victims are merely witnesses here, PW1, PW2. But here you have victim's role is that of a participant. The victims receive notice, they have an opportunity to speak, and they defend their interests. They have the victim impact statement, which we still do not have in India. So the victim impact statement. So the victims, they have an opportunity to speak, they have an opportunity to defend their interests, but what happens if their rights are not respected? And what happens if they're not given their rights? If this happens, God forbid, his rights are denied, then what happens? He dives in hook, line, and sinker to enforce his rights in the appellate courts and move from being just a participant in the process to a full-fledged party in an independent civil writ proceeding. This is what I see as a problem, a huge problem in this Crime Victims Act. When the person is not denied his rights, he is expected to file a writ and enter the justice system again. There is no system which will correct itself. There is no system that will enforce the law, of personnel, the judicial officers, the policemen, to carry out their job conscious of the victim rights. The victim has to identify that his right has been denied, and he has to again appeal to set this right. Is this fair? Because he is already a victim in that circumstance, and he should be protected. That is what a victim expects, protection and empathy. And he is not to be there and look for an opportunity and to see how his rights are denied and record it and appeal, again go to another lawyer and appeal in a civil writ proceeding. So this writ proceeding is used to force government officials, including judges, to comply with the CVRA. This is what I see as a problem. Why can't they have a built-in mechanism to set that right, to ensure that the victims are given their rights? I would call this pinching the baby and rocking the cradle. Why should the victim enforce his rights through these writs? Aren't such writs for the protection of the offender, and he has broken the law? But the victim has not broken any law. He is a victim of someone else breaking the law. Why equate the victim with the offender? Why, when the offender is given a writ, you give the victim a writ? But why should he approach the courts once more for justice? Hasn't he already done his bit by filing a complaint in the first place? Like I told you, he's a VIP. He's the one who sets the whole system in motion. So hasn't he already done his job? Isn't this another form of secondary victimization? Let him endure the denial of his rights in the system and then apply and appeal to the same system that has denied his rights. Why can't the state monitor it? Why can't the state enforce the victim rights? So this is the one I identified as a huge drawback in the Crime Victims Act. And when I say getting into the system, it's such a complicated system for people with a criminology background and a law background itself. You see that this system is so complicated. You just look at your screen and you'll say, this is how you enter a system, and this is what happens in a system, prosecution and the proceedings and the adjudication and the sentencing and the corrections. So this is a very, very complex system, and it's not the victim's place to understand the system and to be thrown into the system for the second time. So this is what I mean when I say that the victim's rights and the offender's rights are not equal. And it's a vicious cycle. You throw the victim back into this vicious cycle. So he goes back into the system which has already harassed him, which has already not given him his rights. So you're throwing him back into this vicious circle. And you know the justice system, you know how slow it is, especially in a country like ours. We have the docket explosion. There's a very slow pace. There are very a limited number of judges. So across India, you see the docket explosion. You see that justice is delayed, justice is denied, and we have only 14 judges per million. And these already lead to a lot of complications. And we have too few judges, too many cases. So in this case, if you're going to ask the victim to come back into the system and apply for another writ and appeal again. So do you think this is really victim justice? And then the docket explosion. So what happens with so many cases? You have a few more cases. And when you're looking at all this, you should understand where this victim is coming from. First, initially, he's just been swallowed a little by little. Earlier, the harm that was suffered by the victim, he represented it. He took action for the harm that was meted out against him. So the ownership of the harm suffered by the victim was taken away from the victim. The victim was swallowed by the private prosecutor. You gave him a representative who would go and speak his case. And then finally, the private prosecutor was swallowed by the public prosecutor. And now the public prosecutor is swallowed by the victim lawyer. So finally, you have a hapless victim and happy victim lawyers. So why do you put these victims into that same situation again, is my question. Why can't you have a built-in system to regulate his rights, to monitor and see that he has been given his rights? This is for countries which have victim rights. Less said about India and other countries that do not have victim rights, the better. So again, you see the injustice in this system. Finally, we come to the victim assistance vis-a-vis the crime prevention. So we have many cases of the victim who has turned into an offender. When the victim suffers and he's not reconciled with his victimization, he does not get any assistance after being victimized. So what he does is he attacks the tormentor. So the victim of attack from the target of his abuse. So there are many case studies which show how victimization experienced by the partner is expressed through criminal act against the spouse. So there was a famous case in UK called the Ahluwalia case. It was about a Punjabi family who was settled in the UK, and how the woman was subjected to torture by her spouse, and eventually she set him ablaze. So the case was against her, but then they had this battered women syndrome come up after that in her defense, said that she was suffering from battered women syndrome, which was because of the repeated abuse. She was not in a position to understand the outcome of her act. So this was used as a defense. Similarly, the Lorena Bobbitt case, how a woman, after being emotionally and physically abused, she took the extreme violent act and severed the perpetrator's sex organ. So we see these people end up as offenders. But where did they begin? They began as victims. So they're victim turned offenders. So when you look at the whole gamut of crime, the causes of crime, the etiology of criminal behavior, you see that victimization could also be one of the causes of crime. This is another lecture altogether, but I'm just throwing it in here so that you'll understand how victimization can, and assistance to victims can help prevent crime. So the FBI gives a whole lot of factors which are supposed to cause crime and are supposed to affect the type of crime and the volume of crime. But can't victimization also be included as one of these factors? Because we see that victims who are not given assistance also turn to be offenders. So we have another study, a recent study in 2017 by Wemmers et al., which also says victimization can be criminogenic. Polyvictimization, that is different types of victimizations, together appear to play an important role. The different, as the number of forms of victimization increases, so does the delinquency. So severe polyvictims were all delinquents, whether the majority of non-victims were not delinquent. So this I'm saying here in this context to make you understand the relationship between victim assistance and crime prevention. So no victim assistance. When there is no victim assistance given, they will not report the crime because they think, why should I? What am I going to get out of setting this whole criminal justice system in motion? When I report a case, something is supposed to happen and I'm supposed to be helped. But in the end of it, I see that I get no justice. So when there's no victimization, the victim assistance, there will not be any reporting. And when there's no reporting, there's no reconciliation. So the victim is still thirsting for that justice. So what happens? There is no healing for the victim. The victim internalizes all the anger and the frustration, and the victim does not know how to cope. So one way to cope is to go out and commit a crime, commit an offense either against the person who perpetrated the crime against him or against any other person who reminds him, or maybe just a random act of thing just to get out of his system, get this victimization out of his system. So the relationship between anger and delinquency is very, very strong and positive. So when you internalize the anger, you don't know when it's going to come out, and when this anger comes out, you're likely to commit crime. So can we say the mantra for crime prevention could be victim plus victim assistance equal to crime prevention? Can we say that if a victim is provided with the necessary crime in the victim assistance, then he could be prevented from committing a crime? So victim assistance, it's not vis-a-vis crime prevention, but victim assistance is crime prevention. Now finally, let's move on to the criminal justice system vis-a-vis the victim justice system. So what are we looking at here? The criminal justice system is the ones with the four wings of the criminal justice system that we spoke about in the beginning of the lecture. So our victims will turn away from the system. What happens if our victims do not get justice in the so-called criminal justice system? Our victims will go away from the system. And what happens when they go away from the system? They will find their own way of taking revenge, vendetta, whatever. They will find their own way of getting justice for the injustice meted out to them. So if not for the victim, the criminal justice system in all its glory will be ceased to be functional. Like I said, the victim holds the key. Unless the victim sets the criminal justice system in motion, there is no use for all this. We invest so much in police and courts and corrections every year. But what use of all this if the victims turn away from our system? The whole system is made for them. Now we have international crime victimization surveys. These are surveys done that capture the dark figures. What are these dark figures? When people do not report a crime for many reasons, say, I will not get justice. I do not know, it's too complicated for me. It's too expensive for me. It's too time consuming for me. For various other reasons, victims do not enter the system. So this international crime victimization survey, this has reported that large number of crimes go unreported for various reasons. They did a survey among all the victims who have not reported, and they have collected from 9 countries about the types of crimes that were not reported and the reasons for not reporting. So when you see this, the increase in the dark figures of crime, they are not captured. These dark figures of crime are not captured in our National Crime Records Bureau. Every year we have our National Crime Records Bureau giving us a statistics of the crime in India. But these dark figures are not captured there. So these will be captured only if our victims enter the system and they try to get justice from the system. And for that, the system needs to be victim friendly. It cannot push away victims from the system. It should be able to draw victims and their challenges into the system and provide different means of addressing those challenges, of helping them. So we have a great author who authored a book called The Rich Get Richer and the Poor Get Prison. So he had very nicely put this. Is this a criminal justice system or a criminal justice system? So is the focus on justice or is the focus on criminal? I think this is put very, very explicitly. So we need to understand whether this system that we are all working with and we're all looking up to get justice, is the focus in this on the word justice, or is the focus on the word victim? Another question for us to contemplate. We have the Pyrrhic defeat theory. Most of you must have read about this theory in a different context, but I'd like to talk about it in the context of the criminal justice system. So why is this criminal justice system failing in spite of the fact that we all know that it's happening. For us, we had Justice Malimat way back telling us that this criminal justice system in India favors the accused. And then we had the Justice Verma Commission, which pointed out after the Nirbhaya case about the various victim unfriendly provisions in the system and how to set it right. So in spite of all this, not that we do not know what's wrong, everybody knows what is wrong and what has to be done. But how do we explain the persistence of the failing criminal justice system? Why is this happening? Those who have the power, can we say that those who have the power to change the system actually benefit from the way it operates? Or can we say to determine how a criminal justice system that neither protects society nor achieves justice is still functioning? The aim of this criminal justice system is to achieve justice. The aim of the criminal justice system is to protect society. So how is this system, how is the system still functioning, even though it seems to be so non-functional? So we use this Pyrrhic defeat theory to explain. It's like the Pyrrhic defeat victory. It may be used to explain the persistence of the failing criminal justice system. It may be used to explain how to determine why this criminal justice system is still functioning. And lastly, who is benefiting from this failure? Now we all largely agree that there is a failure. But who is benefiting from this failure? Are the offenders and their associates and the beneficiaries of the current justice system? Are they the ones who are benefiting from the system, from the failure of the system? So is it a Pyrrhic defeat theory? It's a huge question that needs a lot of contemplation and research. So is it the underlying principle of the system that is incorrect or wrong? Where lies the challenge? Is it our interpretation of this system? Is something wrong with that? Again, where lies the challenge? Is it our inability to prioritize? To put a victim above an offender, or put his rights, respect the victim's rights like we do the offender's rights? So where lies the challenge? Is there a lack of readiness to dispense holistic justice to the victim? Is there really a lack of readiness to dispense holistic justice to the victim so we know what's wrong and we let it happen and we let it continue? We need to think about this as well. So we have Susan Herman, who had given 10 guiding principles for a parallel justice system. Like I said, in the UK, the victim rights are just like sticking plaster on the existing criminal justice system. So she's talking about 10 guiding principles of parallel justice or a victim justice system. So there she speaks about justice requires helping victims of crime rebuild their lives. So she is a police officer in New York City. I met with her, Susan Homan, and she has given these 10 guiding principles. So it would be wonderful if most of our countries can look at it like this, a parallel justice system or a victim justice system, where justice requires helping victims of crime rebuild their lives. Something giving the victims what they need. They need to rebuild their lives, not to run from pillar to post in the courts and in the police stations and getting nowhere at the end of all that. And one thing we must remember is all victims deserve justice. We cannot prioritize and say this victim is more important, this victim is less important. All victims deserve justice. All victims should be presumed credible unless there's reason to believe otherwise. Every victim is a credible victim, and victim safety should have top priority. You cannot compromise on that. When a victim has the courage to come and complain about a crime, you need to encourage that. You need to protect her or him when he or she does that. And victims should experience no further harm. They've already suffered a victimization. So when they come to the system, they need to be protected from further harm. You need to guarantee that protection. Then victim rights should be implemented and enforced. We need to have a legislation to protect victim rights and to enforce victim rights. Victims should have an opportunity to talk about their experiences and their needs in a court of law, like the victim justice system. Somebody needs to ask them, what do you want from the system? What are your needs? What are your expectations? And recording their experiences, we need to see what we can do to improve the system. Victims should be told what happened to them was wrong. They should be reassured that they were wronged and that every effort will be made to rebuild their lives. They need that assurance from the system. Otherwise, they will not keep coming to our system. They will turn away from the system. And victims' needs should be addressed through comprehensive, coordinated, communal response. Every one of us need to take accountability for the victimization. It has to be a coordinated communal response. Decisions about how to address victim needs should be based on sound information and research. That is where all the academicians come in. We do a lot of research. We should base our policy on the research. Our research should be of a good standard, and this should be used by the government agencies and make policy changes depending on our research, based on our research. So this is where we become very, very accountable. Our research should be of a very good standard. There should be honesty, there should be transparency, there should be accountability in all the research that we do, so that these volumes of knowledge that we get out of our research can be used as a basis for the policy making by the government and by the other agencies. So these 10 guiding principles given by Susan Herman are something I think that all countries across the globe can use as a basic when you're trying to look at victim rights. So finally, we have the victim justice system, where the victim is guaranteed access to justice. We have a victim justice system that's guaranteed fair treatment to the victim. We have a victim justice system that guarantees restitution. Restitution and compensation are used interchangeably in our country, but that is not it. Restitution is what comes from the offender, and compensation is what comes from the state. So victim justice system should ensure assistance to all victims of crime, different types of assistance, physical assistance, psychological assistance, financial assistance. All this should be incorporated in our system. If we need to call it a victim justice system, you need to do this. You cannot expect a victim to stand on his or her head like you see here, just to get her rights. And she or he has already been denied the right to protection, the right to safety because of the crime that has already been committed. That is paramount. That should be paramount in our minds when we are addressing a victim's needs. And the criminal justice system, we are not denying the offender his or her rights. The offender needs to be protected. The offender has to be given his rights. But you continue to give the offender's rights, but not at the cost of the victim rights. That's all that we are saying. Continue giving the offender. You cannot pit reduce the offender's rights just to give the victim his rights. You need to bring about a balance. You need to continue giving the offender his rights, but not at the cost of the victim rights. You need to find a way to balance the rights of the victim and the rights of the offender. There is an NGO called Human Rights Watch. They have envisaged this: rights of the offenders plus the rights of the victim is equal to justice and rule of law. So a criminal justice system based on human rights standards can safeguard the rights of both the victim and the offender. This is what we should look at. We need to, at the end of it, have justice, and we need to have the rule of law. In every country, you need to have the law that rules. The law is supreme. That is when you can ensure that both the victims and the offenders have their rights respected. So we have to try to do this balancing act. This looks impossible, but there is a way. We need to have set our mind to it to ensure that the victims and the justice and the offenders get their rights. So towards the victim justice system, the need for a balancing act. Finally, we hope to have a balance between the victims and the offenders and move towards a victim justice system. So I'd like to end with this saying by Maya Angelou. She says, I've learned that people will forget what you said, people will forget what you did, but people will never forget how you made them feel. This is exactly what a victim remembers when he or she gets out of the criminal justice system, how the criminal justice system made them feel. In many of our studies, we've recorded the experiences of these victims. So we need to see that you make the victim feel comfortable when he or she walks into our system and when he or she walks out of our system. I rest my case. Thank you for your attention, and I'm happy to take any questions.